Imagine trying to make a literal legal ghost sign, a multi-million-dollar legally binding contract.
Oh, wow. Yeah, that sounds impossible.
Right. But that is exactly the mission for you on today's deep dive. We are demystifying the highly sophisticated world of Mexican corporate representation.
Because it is a completely different beast compared to just normal contracts.
Exactly. We need to figure out how a fictional entity, a corporation that really only exists on paper, can legally act, speak, and actually obligate itself in the real world.
And doing that requires a very, very precise set of legal mechanisms. I mean, if you just assume a signature is valid because someone holds a fancy title, you risk the entire agreement collapsing before the ink even dries.
Okay, let's unpack this. To understand how this fictional company acts, we first have to separate who is doing the acting.
Right, the actors themselves.
Yeah, because we are looking at two very distinct layers of authority.
Yeah.
First, you have what's called organic representation.
Which is basically the sole administrator or the board of directors.
Yes.
In the eyes of the law, they don't merely represent the company. They essentially are the company. Like, their authority is born with the corporation through its articles of incorporation.
So they don't need a separate piece of paper.
Exactly. They don't need a separate power of attorney to act because their power is just inherent to their role.
They are the actual brain of the organism. But a brain can't be everywhere at once, which brings us to the second layer, voluntary representation.
Yeah, the proxy.
Right, when the company grants a proxy or an apoderato to a third party, like an external lawyer or a regional manager, I used to think of this as giving someone a megaphone.
A megaphone, sure.
But really, it is much more like attaching a programmed robotic arm to the company. The arm has no inherent power of its own.
None at all. It can only execute the exact rigid tasks the brain coded it to do. That is a much better way to visualize it. The legal mandate strictly programs what that robotic arm can actually reach for.
Which naturally leads to the question of what we actually allow that arm to grab. Because Mexican law divides these powers under Article 2554 into a strict tripartite classification.
Right, 3 distinct buckets to compartmentalize risks.
Exactly. First, you have lawsuits and collections, which allows the proxy to handle litigation.
So court representation, yeah.
Then there is administration for running day-to-day operations.
Signing standard service contracts, things like that.
Yeah. And finally, acts of ownership or dominio.
Oh, that is the absolute highest level of corporate risk. That power allows a proxy to sell, mortgage, or even donate the company's core assets.
Wow.
Yeah, it is literally handing over the keys to the kingdom. The law explicitly separates these 3, so a company can hire an attorney to fight a lawsuit without accidentally giving them the power to sell the entire factory.
That compartmentalization makes perfect sense. But let me push back on the day-to-day side of things for a second.
Sure.
Wait, so if I have an administration power to run the business, does that mean I can automatically sign checks?
What's fascinating here is absolutely not.
Really?
Yeah, general administration power is intentionally walled off from the company's cash flow. Handling bank accounts or signing credit titles like promissory notes or checks falls under a completely different rule, specifically Article 9 of the LGTOC.
Oh, so it's a completely separate law.
Exactly. The law requires a totally separate, explicitly stated special power just for credit operations. Basic admin power isn't enough. Without that highly specific legal coding, your signature at the bank teller is basically invisible.
Wow, okay. So the law tightly regulates the scope of these powers. But what prevents the organic brain, the board of directors, from just, delegating all of their own headaches to a proxy?
Well, that hits on the golden rule of corporate governance found in Article 147 of the LGSM.
Which says what exactly?
It says an administrator can grant a proxy to handle external company business, sure, but they absolutely cannot send a proxy to sit in their own seat at a board meeting and vote on their behalf.
Because the shareholders elected that specific person's judgment.
Exactly right. You cannot simply outsource a fiduciary duty. The collective judgment of the board is non-delegable.
That makes total sense. But how do you actually prove all this authority in the real world?
That brings us to the corporate tract, under Article 10 of the LGSM. When a company grants any power, a notary public cannot simply draft a quick authorization letter.
They have to dig into the history.
Oh, meticulously. They must transcribe the entire legal chain of authority. They have to document the original incorporation, the specific shareholder assembly minutes, and objectively prove that the individuals voting actually had the legal standing to grant the power in the first place.
They basically have to lay down the entire track of the corporate history just to prove the train can legally run.
That's a great analogy, but this raises an important question. What happens if a notary gets sloppy and skips just one link in that historical chain?
I'm guessing the courts don't like that.
They hate it. They view that omission as a fatal flaw. The entire power of attorney can be instantly nullified for a lack of personality.
Oh, wow.
Yeah. The proxy loses all legal standing, and any contract they sign is essentially voided.
So what does this all mean? We started by asking how a fictional entity interacts with the real world.
And the reality is that its existence relies entirely on an unbroken, perfectly documented paper chain.
Yeah, if even one link is missing, the legal ghost just vanishes, and the multi-million-dollar agreement completely falls apart.
It is entirely built on trust and a flawless paper trail.
Absolutely. So the next time you sit down to sign a major business contract, ask yourself, did the person sitting across the table actually possess the exact, unbroken chain of legal authority to bind their company? Or could their signature just be a meaningless legal fiction?